It's time for Talk Law Radio with Todd Marquardt. Todd Marquardt, attorney at law in Texas. If you're a millionaire or a thousandaire, Talk Law Radio is now on the air. Call in with your business law question, your elder law question, veteran aid, Medicaid, build a business to get paid. 210-308-8867. Or ask a question online at marquardtlawfirm.com. That's MARQUARDT lawfirm.com. And now it's Talk Law Radio with Todd Marquardt.
Welcome to Talk Law Radio. I'm Todd Marquardt. I'm podcast everywhere, Facebook, YouTube, and talklawradio.com. Today we're going to be talking about medical power of attorney, directive to physicians, do not resuscitate, and physician-assisted suicide. Before we get started talking about the law, let's begin with prayer. Dear God, thank you for this day. Thank you for all the gifts and blessings that you give to us. Please forgive us for our sins, for our mistakes, for doing the wrong thing or failing to follow your will. Please help us to follow your will more closely. Help us to use the gifts and talents that you've given us for the good of your people, for our own good, and for your glory. In Jesus' name, amen. Now it's time to discover your legal issue blind spots by listening to me talk about the law on the radio. And today we're going to be talking about, do you really know the difference between medical power of attorney, do not resuscitate, directive to physicians, also known as the living will? Well, I'm going to go into some depth here and give you some general information about what's included in the statutes and what decisions can be made and who can make them. This is important stuff because medical and health care affects your life, literally, right? So you can make your own medical decisions so long as you're competent to do so, and so long as you're awake and you understand what your choices are. If you lose that ability, well, your agent under medical power of attorney can decide that for you. But here's the catch. You have to sign the medical power of attorney before something bad happens. Because if you're already unconscious, well, you can't sign it and nobody else can sign it on your behalf. So the important thing to do is to get a medical power of attorney as soon as possible. Everybody over the age of 18 should have one. Why? You think 18-year-olds aren't going to have accidents? Well, what's the most dangerous thing most of us, almost all of us do? That's get in a car and drive in traffic. And if you drive on 410, 1604, I-10, I-35, or 281, you need a medical power of attorney. And maybe you already have one. That's great. You named somebody you trust, and hopefully you named two alternates just in case, God forbid, something bad happens to either one of them. But let me explain exactly what decisions your agent under medical power of attorney will make and what decisions you can make in advance. So you can choose your doctor, you can choose your hospital, and you can choose your course of care. You can even refuse care or treatment if you're competent to do so. And so what does that mean? Well, you probably have a whole list of choices between physicians or specialists or surgeons that you do research on and get recommendations for so that you can get the best health care that you can, right? It's not something that you want to settle for, is it? And so you want to choose somebody as your agent that would do the very same thing. Don't just pick your oldest son because he's the oldest. Pick the person that has good judgment. In fact, pick the person who you never have to remind to charge their cell phone. If you have a friend or family member or adult child that's constantly not accepting calls or text messages from you because, quote, my phone was dead, maybe that's not somebody you want to put your life in their hands. Also, I think it's good to pick somebody who lives nearby or can drop everything like a hat and be at your bedside at the hospital. I think physicians and everybody in the medical industry, those are the highest trained professionals that we have in the United States. They go to school for years, even decades. But have you noticed that sometimes they're busy? Sometimes they're rushing around the hospital. Sometimes they don't give you all the information that you think that you deserve. What are the alternatives to the recommended course of treatment or care or medication? They don't always just give that to you right off the bat. Sometimes you have to ask for it, right? Well, I would want my agent under medical power of attorney to ask those tough questions. I've heard stories, anecdotes from clients and friends and neighbors about how even though they don't know anything about medicine, they stopped a mistake from happening. You know how they did it? They asked, "Why are you doing that?" And it doesn't really matter what the answer is. I mean, you're not going to know if they're lying to you or if they made a mistake. But I've had people tell me just by asking that question, they saved their loved one's life because the medical professional answering that question said, "You know what? I think I'm going to do something else. I'm going to change this, that, or the other." And that brings me to another point. I think it's good to pick somebody who's able to confront those who seem to be in authority. Physicians seem to be in authority because they're supposed to know everything, right? And so you want to have somebody who's strong enough, courageous enough to confront that person and ask, "Why are you doing that? What are the alternatives? What happens if you don't do that? What's the most conservative course of treatment here? What's cutting edge? What can we do?" And those are tough questions, especially when the person that you're confronting is maybe in a rush or doesn't want to take the time to explain to a non-medical professional all the ins and outs of what's going on. So those are some tips that I think about when trying to decide who's the best person to be agent under medical power of attorney. Now, in the medical power of attorney statute, it says your agent may consent, refuse to consent, or withdraw consent to medical treatment and may make decisions about withdrawing or withholding life-sustaining treatment. More on that later because you can decide in advance some of those decisions. Now, here's what they can't do. Your agent may not consent to voluntary inpatient mental health services, convulsive treatment, thank God, psychosurgery, thank God, or abortion. A physician must comply with your agent's instructions or allow you to be transferred to another physician. So that's probably enough on medical power of attorney. It's a permission slip to allow somebody else to use their judgment to make medical and healthcare decisions for you. Now, on the medical power of attorney, there is a space where you can put instructions. And so for some people that are more instruction-based planners instead of permission-based planners, I help them come up with ideas that matter to them about what type of treatment they definitely want to have and types of treatment that they definitely don't want to have. And so if your attorney is not asking you about that, if your online web form is not asking you about that, maybe they should be. Maybe you should contact an attorney that asks these questions to customize plans for their clients. Now I want to switch over and talk to you about Do Not Resuscitate. Remember, this is Talk Law Radio. I'm Todd Marquardt on 9:30 a.m. The Answer, Sunday afternoons at 4:30 in the afternoon. Remember There's also a show Saturday mornings on 9:30 a.m. The Answer, also 6:30 a.m. The Word, also KNTH in Houston 1070 a.m. and 103.3 FM at 11 o'clock in the morning on Saturdays. So tune in, and if you miss an episode, find us on Facebook, find us on YouTube. Go to YouTube, click the magnifying glass to search for Talk Law Radio. Look for the Lady Justice logo in the red, white, and blue colors and click subscribe. That way you can get notifications when we post new episodes. And you don't have to listen to the whole show all at once. They're broken up into 4 segments that you can watch while you're washing the dishes, walking the dog, or working in the garage. Okay, now we're going to talk about Do Not Resuscitate, or DNR. A lot of people think that that's the directive to physicians, but it's not. So I'll make it clear how they're different. But first, Do Not Resuscitate is a doctor's order. So if you say, I don't want chest compressions, I don't want my heart to be shocked, if I pass out, if I'm unconscious, if my heart stops, the doctor is going to ask why. Because CPR is about 70% successful. People have their heart stopped, they're actually dead or dying, and somebody jumps on top of them and starts pushing on their chest. 70% of the time, they're able to be brought back to life. And so that's why the doctor just wants you to be fully informed about what those procedures are and how that works. And so a doctor has to sign it, even if you want it. And we can do this form in the law office, but you can get it at your hospital or you can get it online. It says the out-of-hospital Do Not Resuscitate order allows patients to direct healthcare professionals in the out-of-hospital setting, like paramedics, to withhold or withdraw specific life-sustaining treatments in the event of a respiratory or cardiac arrest. The law defines out-of-hospital as a location in which healthcare professionals are called for assistance, including long-term care facilities, nursing homes, inpatient hospice facilities, private homes, hospital outpatient or emergency departments, physician offices, or vehicles during transport. Who is a healthcare professional? The law defines healthcare professionals as physicians, physician assistants, nurses, emergency medical services personnel, and hospital emergency personnel. What life-sustaining treatments are prohibited? Cardiopulmonary resuscitation, that's CPR, pushing down on the middle of the chest when a heart has stopped beating to help beat the heart, and breathing into the lungs through the mouth to fill the lungs with air for a person that has stopped breathing and whose heart has stopped beating. This is a different type of resuscitation called transcutaneous cardiac pacing. Pads put on the outside of the chest so an electrical impulse can be sent to the heart to try and regulate certain irregular beats that could be dangerous to a person's life. Defibrillation, an electric shock put through the chest to try to start their heart beating again when it has stopped. Advanced airway management, when trained people put what looks like a clear tube into a person's mouth when that person has stopped breathing or is not able to breathe well on their own, to breathe for them. Artificial ventilation, when trained people use a football-sized bag and a mask that fits over the person's mouth and nose to push air into the lungs when the patient can't breathe on their own or have stopped breathing. So that's the Do Not Resuscitate. How is that different from the directive to physicians? Well, the directive to physicians is a separate document. A lot of times we do them in the law office because we're talking about incapacity, life or death, and making decisions in advance. This is known as the living will. Remember Terry Schiavo, the woman in Florida who in year 2000 had a court case that went all the way up to the Supreme Court? Well, the whole issue was, can her life support be removed? Well, she had a heart attack, I think, when she was 35, and they brought her back to life using CPR, but she was without oxygen for too long, and so there was brain damage. They said that she had no brain activity. She was a vegetable, so to speak. And so the question is, can we withdraw her feeding tube? That was the only life support that she needed. She was breathing on her own. Can we withdraw that life support and allow her to die naturally? Well, in Florida, where she lived, if you didn't have a document like a directive to physicians or a living will, then the court would consider what she would have wanted. And so her husband, who already had been dating somebody and had kids with another lady, said, oh yeah, it's been 15 years, Terry Schiavo's been on life support. I just remembered. She never wanted to live this way. And her parents said, no, we specifically remember talking about this issue, and she told us she would have wanted to keep trying, to keep her alive. Maybe science and technology would develop and they'll figure out a way to wake me up. Well, because there was conflicting testimony, there was appeal after appeal, went up to the Supreme Court, and the Supreme Court said, state law decides. And so if there's conflicting testimony, Florida law said that there was a list of people that could decide to withdraw or withhold life support for another person based on their relationship to that person. And at the top of the list is spouse. And so her spouse said, if I can't prove that she would have wanted this, I get to decide anyway. They withdrew the feeding tube, and she died because she had no nutrition. But that was the life support that was keeping her alive. Same thing in Texas. Artificial nutrition and hydration is considered to be life support. More on that later. I'll talk about somebody else's definition of life support. So you do the directive to physicians, and you decide in advance if you want to withhold or withdraw life support, or if you want to be kept alive. If you have a strong preference, you don't have to do this because your agent under medical power of attorney can decide this for you. You do this if you want to, like I said, stay alive as long as possible, hope that science and technology will develop a cure or a way to wake you up and bring you back to normal, or if you want to save your family the heartache and the headache of having to decide to pull the plug and to allow you to die. So, like I said, it's a choice. But let me define some things for you. First, on the form it says, if in the judgment of my physician. So, your physician has some authority in this matter, and you have to have some trust here that the physician is going to make a written diagnosis that's going to lead to a pull the plug or don't pull the plug type of decision. It's sort of like algebra, sort of like math. If in the judgment of my physician I am suffering with a terminal condition from which I am expected to die within 6 months, even with available life-sustaining treatment, provided in accordance with prevailing standards of medical care. So what does terminal condition mean? It means an incurable condition caused by an illness, injury, or disease that, according to reasonable medical judgment, will produce death within 6 months, even with available life-sustaining treatment. So this is different than terminal cancer, because some people with terminal cancer can still go to the grocery store. They're still awake. They're just terminal. They're expected to die within 6 months. This is terminal and you're in a coma or a vegetative state. And so in that situation, would you, choice one, want to discontinue or withhold treatment, or choice two, would you want to be kept alive? Life-sustaining treatment means treatment that, based on reasonable medical judgment, sustains the life of a patient and without which the patient will die. It includes medications, artificial life support such as mechanical breathing machines, kidney dialysis, artificial administered nutrition, and hydration. It does not include pain management. So even if you say withhold or withdraw life support, you can still get your pain management and comfort care. So what is artificially administered nutrition and hydration? Well, that's IV fluids or a feeding tube. Okay, the other situation is irreversible. So terminal is irreversible, but irreversible is not necessarily terminal. So those are the two situations. If you're in a coma or a vegetative state and you receive life support, but the doctor doesn't know whether you would live 6 months, 6 years, or 16 years, would you, choice one, want to withhold or withdraw life support? Or choice two, would you want to be kept alive? So those are the choices that you can make on a directive to physicians. Now you should consult your conscience, you should consult your religious text, and you should consult your family members if you want to. If you think that the kids or the other family members will argue about whether or not to pull the plug, this is a good way to give them some guidance on what you would have wanted. Okay, let's talk about one more thing. Physician-assisted suicide. How do you feel about it? Well, we don't have that in Texas, so whether you like it or you don't like it, a physician is not supposed to help you end your life. But as of February 2026, my research shows that physician-assisted suicide, also known as medical aid in dying or death with dignity, is legal in the following 11 states: California, Colorado, Delaware, Hawaii, Maine, Montana, New Jersey, New Mexico, Oregon, Vermont, and Washington. And coming soon in Illinois, September 2026, you'll have physician-assisted suicide. Email me and tell me what you think. host@talklawradio.com. That's HOST@talklawradio.com. Or post a comment on the Talk Law Radio Facebook page. Or if you're watching on YouTube, post a comment there. Now, there were lots of Supreme Court cases in the 90s about death and dying. And the first case was in 1990, Cruzan versus Director of Missouri Department of Health. And this is the case that said that a patient is allowed to refuse medical treatment. And so it didn't say anything about physician-assisted suicide, but this case sort of led to that over the decades. Washington versus Glucksberg in 1997 said there's no fundamental constitutional right to physician-assisted suicide. There's no right under the Due Process Clause. And so states at that time wanted to prohibit physician-assisted suicide. And this was Washington State. In 1997, wanted to prohibit it, and now in 2026, it's expressly permitted. Then there was Vaco versus Quill. It upheld New York State's prohibition on assisted suicide. Then we jump 9 years to 2006. Gonzalez versus Oregon upheld Oregon's Death with Dignity Act and said that the state cannot use the Controlled Substances Act to prohibit physician-assisted suicide. Well, I have to close out this show. I really enjoyed talking to you about this. I help a lot of people with this, but I want to end with one final thought, because I know that you're praying for your loved one who's ill or injured and trying to recover. I was in that situation at one point too. Trust God. He may not give you what you want, but He gives you what is best. Talk to you later. Bye.